और बिल्किस बानो गैंग रेप के दोषियों को लेकर लोगों में आक्रोश पैदा हो चुका है। गुजरात सरकार पर लोगों ने नाराजगी व्यक्त की है। हालांकि दोषियों के वकील ने कहा कि कानून में छूट खराब नहीं है। राज्य सरकार ने शीर्ष अदालत के आदेश का पालन किया है।
Release the remission release of all the 11 convicts has in fact sent shockwaves across the country, and in fact there is a national outrage over it. How do you react to it?
The two aspects which I really want to talk about is this: if this so much was the shocking incident, then why didn't the High Court or the Supreme Court awarded death sentence? That's part number one. Because the High Court awarded life, the Supreme Court confirmed the life imprisonment. No question of death sentence either by the High Court nor by the Supreme Court. At that time, there was no opposition. There was no hola, no rolla about this thing that why the death sentence should not have been there. In fact, on the contrary, the victims were happy with the higher amount of compensation which the Supreme Court granted 5-6 years down the line. Now, the second aspect which is most important and one must understand is this, that the law for last 20 years and which has been reiterated in this case by Supreme Court in May 2022 is this, that a remission policy which is applicable at the time of conviction by the trial court, that has to be seen and not a subsequent policy of any state government. Now in this case, there were two policies which are in question now. One was the state Gujarat government's policy of 1992 and other policies of 2014. Now, 1992 policy says very clearly that an accused must suffer at least an actual sentence of 14 years before his case is considered for premature release. But in 2014 policy, they added a new clause that in case the investigation is conducted by CBI, they have to take permission from the central government in order to enable the case for premature release. So in this case, when the 2008 trial court convicted the accused person, the only policy which was applicable was year 1992. And which did not have all these clauses which have been incorporated in 2014. What the Supreme Court has done has just to reiterate a 20-year-old law judgment which says that a policy which is applicable at time of conviction, that has to be seen. In that judgment, Supreme Court also held that the trial was transferred for a limited purpose, but for all intent and purposes, it would be state of Gujarat which would be applying its remission policy.